to Edward Wilde, our legal expert and also member of FCI Legal Committee. You know Edward from last time, but he will talk about different topics today. So he has a very good presentation with 2 parts. By the way, during the presentation, if you would have questions related to his presentation, of course, please type your questions in the chat part, in the chat area on your screen. And then at the very end of the day, of the conference, there will be a specific special legal Q&A session, and we will be together with Edward, and he will give reply to your questions. Please don't forget to type your questions in the chat area. Thank you. Edward, the word is yours.
Good morning. Good morning. I'm very happy to be back. Before I start, I'd just like to comment on some of the previous speakers. I have had the benefit of a long discussion with Vladislav as to your intentions, and I'm very happy to dovetail this presentation, which I hope will match some of your aspirations. Also, I would like to emphasize Kamola's concept of cooperation and collaboration. It is absolutely essential that whilst you are all competitors in this market, on the basic functions such as education, common procedures, and most importantly, discussion with the authorities, that you do cooperate. You are not competitors in these areas. And Peter has emphasized the dangers of regulators with a poor understanding of factoring. And this reminds me of a year I had in negotiations with the European Commission, who took it upon themselves to decide that factoring, non-recourse factoring, was a form of insurance. Now, none of the factoring companies in the UK are registered as insurers unless they happen to be major banks, and to operate without an insurance license is a criminal offence. So very important that you use a common approach to ensure that regulations are for the benefit of successful factoring. And therefore, I have entitled this speech, Successful Factoring, Using Regulations and the Law, and there is a question mark at the end, because I'm going to just mention, as I did last time, the fact that in the UK we have no regulations. But in my view, I think that in the early stages of developing the factoring industry, regulations would be a good idea. And the fact that we have no factoring laws in the UK may or may not be a benefit. Next slide, please. And the next one, please. Okay, so I'm going to give you a story in 2 parts. I will just quickly tell you of the success in the UK without regulation. But there is a reason for this, and I will come to that. And it's one that I think you will find of benefit in your future plans. And then the second part are the issues for a trade association. And I have had 25 years as legal secretary of our Factors and Discounters Association. It is not an easy path. It takes a long time because we started off with factoring both in commercial terms, legal terms, and legal terms. It was considered as a lender of last resort. Anyone who took a factor would shortly become insolvent. And indeed, there were factoring companies that made a lot of money in taking on clients who were about to go insolvent because they could raise extra charges and there was a lot of money to be made out of helping a company for, say, a year and then allowing them to become insolvent. This is something which you have to overcome, and our problem in the UK is that we have a very inquisitive press, and you can spend a year building up a good reputation and it can be destroyed by one bad press article. Next slide, please. So just to remind ourselves where we are in the UK, no regulations, no specific factoring law, 400 billion of receivables factored last year, with 28 billion US dollars at any stage being advanced to clients. 42,000 clients, which is a figure that never seems to go up, but what does happen is, and it's a testament to the success of factoring, is that the turnover of those clients does increase, and the advantage is obviously that there is greater flexibility in lending levels than straightforward bank loans. And the most successful product, taking 80% of the market, is the confidential invoice discounting. So an assignment of the receivable, but the debtor is not advised unless the client is in breach of the agreement. Next slide, please. Next slide. Yep. Okay, just a few background issues. There's no restriction on anyone owning a factoring company. You can come from Timbuktu, or you can come from Europe or America. You can own a factoring company. Nationality is irrelevant. And secondly, who can manage or work in a factoring company? Anyone. There are no restrictions. There's no qualifications or approvals needed. Now, this is an area which is very sensitive, and that is why one of the first benefits of any trade association is to ensure that people are given knowledge, are trained properly. Next slide, please. Next slide. I think this is self-evident. Anyone can lend money to a factoring company. Anyone can take shares, bonds, debentures. There is no restriction at all. And so we have factoring companies in the UK owned by European entities, owned by American entities. I'm trying to think of other areas. Oh yes, we have one owned by an Australian. So anyone can provide finance. Next slide, please. This is a picture of our Bank of England, and this is a tourist bus going past, and you would think that the Bank of England would be regulating factoring companies. The answer is it's not. There's no specific regulations for factoring companies. There is no licensing of factoring companies, no licensing of their staff, no product requirements or restrictions, and so there is no dedicated regulator. And laws which are generally applicable to all businesses apply. Next slide, please. Now, so this is a personal opinion that the absence of regulation has helped the development of factoring. As I've mentioned before, we were the lenders of last resort with a very poor reputation. Judges hated us, and we usually got judgments against us if there was any doubt. And now factors are mainstream providers of working capital to the small and medium-sized enterprises, the SMEs. But here's the but. In my view, it is the result of an effective self-policing trade association. We started off as the Factoring Association, and that was for 25 years. Now we've merged into the wider Banking Association. What is this? What is the main efforts of the association? Well, to avoid reputational damage, as soon as you get damage to your members or to the product, then the authorities will want to impose regulations. So avoid reputational damage, because reputational damage leads to interference by the authorities. And that is the aim of being a trade association. Now, I will come in a moment. I think there are benefits of regulation. But if there is to be regulation, you as factoring companies and banks should be in at the start to ensure that the regulators understand the product, understand the benefits, and most importantly, everyone is clear as to why they want regulation or are prepared to accept regulation. Next slide, please. So, repetition, but this is a subject that can be repeated. What are the benefits that we have received or we have noticed of having our factoring association? Most important is reputational damage is avoided. And I'll come to how we do that in a moment. Sharing best practices and knowledge. For the smaller factoring companies, this was the most important reason for joining. They did not have the resources to train their staff in-house, and therefore it was better to train with the rest of the industry. The side effect of that, of course, was networking, and the most important aspect of the networking to a small company was that they thought that their problems with clients, with debtors, with third parties were unique to them. And then they came along and they came to presentations with 100 other factoring employees or executives, and they found that these were all common problems. And in doing so, they were able to come to a common approach. So education, education, education. Third benefit, you speak to the government and to the regulators with a single voice. Governments want one party to go to. They don't want to have to talk to 30 or 40 banks and getting 30 or 40 different approaches. So speaking to the government with a single voice is very important. And what it does mean is that differences that you may have between you and which can be used by an offensive regulator are resolved behind your closed doors before you approach and discuss and negotiate with prospective regulators. But I come back to Kamola's concept, cooperation, collaboration. If you cooperate, and this is my experience in other countries where I've had to draft laws, cooperate with the authorities, You educate them because they won't know a lot about your business, or they won't know the details of it. You can avoid these crazy regulations that Peter has already emphasized to us. So there are there are more benefits, in my opinion, of having a trade association than being unregulated. Next slide, please. So this is how we as a trade association have protected ourselves. I've mentioned a common training program. We also have our own examination system, giving diplomas, certificates, and so we have common examinations, common qualifications. We have for people who've been through the system, we have residential weeks with a lot of play acting. My specialization is putting court cases together, and then the delegates have to argue or defend the cases. It's usually where there's fraud involved and guarantors are being called upon. But apart from knowledge, it's very important. Remember, we do not want damage to the reputation of either the members or the product. And this is effected. We have a code, which I'll come to. I'll tell you what's in it in a moment. But the members, as an obligation of membership, have to abide and obey common duties to clients. That's the code. And then if a client or a guarantor considers that there has been some breach, or just if he has a complaint, and most complaints will come within the code, then there is an independent complaints procedure which uses mediation. This avoids going to court. This is very quick. It's done in weeks rather than the years that it would take to go to court, and there is no cost to the complainant. And then we keep this up to date by having an independent standards council. And I'll tell you who's on that in a moment. But they are not members, they do not have a majority of members from the industry. They are there to protect the possible clientele. They look after the interests of the SME. There is a minimum capital for membership status. It's not unreasonable. I think it's about £1 million, about $1.3 million, which in terms of a factoring company will probably cover you for 5 or 6 clients. So it's not exclusive, this, and indeed our competition authorities will not allow us to be an exclusive club for the big boys. Next slide, please. Okay, so we call it the standards framework. What is our aim? Well, the principal aim is to give clients and guarantors confidence in using factoring. For many of them, it's a product that they probably don't know about or don't know a lot about, and they need to be confident. And it's one of the obligations before you sign a client is that you have to explain that there is this code complaints procedure. So when we set it up, when we wrote it about 8 years ago, our aim was to be of benefit to the SME. We wanted it to be as independent as possible, easily accessible. So, as I say, there is no financial cost to the client in going for mediation, whereas if they went to court, there are considerable costs involved. It's focused only on factoring. So this is not part of a general security code. And in our view, it is effective. And I'll come through, and at the end, I will tell you how effective it is. So it comprises three core components. So there's the code of conduct, which I'll go through in a moment. There's the complaints process using an organization called Center for Effective Dispute Resolution, which has about 20 years experience of commercial disputes. And then there's the Standards Council, which keeps the code under review, and the majority of its members come from outside factoring. Next slide, please. Next slide. So here's the code. What we wanted was fair treatment of clients and guarantors. Remember, you always are the stronger party in the relationship with the client. The client wants your money, and you can be a very strong and overbearing party to the relationship. And this aims to overcome that. You've got to be fair. Compliance is a condition of membership. So the majority of factoring companies consider that membership of the association is a benefit. I was asked the other day, how do you stop people leaving the association? Well, the answer is there are more benefits in being members of the association than there are being outside. But compliance with this code is a condition of membership of our association. We've avoided detailed rules. It is principles based, and the principles, I'm sure, you cannot deny are of benefit to a relationship. There, as I say, there are five, well, actually there are six, but the first one is just to abide by the code. There are five principal requirements, which I'll go through in a moment. And then what we have done, we have written a guidance for each principle, which basically gives you examples of what we mean. So the first one is that you must act with integrity. You must deal fairly and responsible. Do not use your overbearing strength against the client, because remember, and I hope it's the same in the Ukraine, we have a very active and inquisitive press who are the first to report the wicked bankers. Indeed, there is a rumor going around the industry that the press will pay a large sum of money for a photograph of a banker with a large glass of champagne in his hand. This sells newspapers. So act with integrity, be fair. You must provide information on time. You must ensure that legal documentation is clear. It's no good writing a complex document in small print that goes for 50 pages, which covers every eventuality, which is written in the UK. You know, we've got documents that were written 100 years ago. You cannot do that. It's got to be clear, simple English, and you've got to describe what happens. I will come in a moment to the reason for complaints, but the biggest cause of complaints is fees, what you charge to your clients. Why is that? Because all the client wants is his money up front, and he doesn't realize that if he breaks the agreement, your fees go up. If you terminate the agreement, you come off risk, etc. Ensure this is all clearly set out. Obviously, comply with your legal agreements, and you must have a publicly available complaints procedure. Next slide, please. One of the benefits of membership is that if a client wants to move from one bank to another or one factoring company to another, there is an agreed handover procedure. It's supposed to take place within a matter of days. There are agreed documents which everybody will use, and it works very well. There's an agreed timetable. If there's any money to be handed over, the procedures are set out and the timetables. And it also covers the very difficult question of bank references. People were unwilling to give references. So we had to say, well, you can give a reference, but it's on the basis of no responsibility. But this handover procedure works so well that most people forget about it, and certainly the clients are unaware of how effective it is. Next slide, please. Complaints. And as I say, we are here to protect your reputation. Complaints are usually about fees and the effect of breaches of the factoring agreement or termination. And it's designed to be a benefit to the client. And first of all, the complaint has to go to the member using their in-house procedures. And then if there's no resolution in-house, then it goes to the mediation center. Now, it is independent. It will suggest financial awards. Remember, this is mediation, so these are only suggestions which the parties are free to agree to or not. It's not arbitration. It recommends improvements to the industry. Vital, there is no cost to the client. The member pays everything. Costs are about $1,000 a case, so it's worthwhile using your best endeavors to sort it out in-house before it goes off externally. It is, of course, confidential. It takes, this is the interesting thing, takes about 50 factoring cases a year. So it's one a week. And approximately 45% of the cases give some award, and I emphasize some award in favor of the client. The client usually wants the earth or the moon. They will get something. So it's worth remembering that nearly half of the complaints have some measure of sufficient grounds in them for there to be an award. The client doesn't have to accept the award. He can reject it and take it to court. Next slide, please. And then we have the Professional Standards Council. Remember, they are the people who write the code and keep it up to date. So it's independent of UK Finance, which is the trade association. It has 7 members. The chairperson is not a member and cannot be a member of a factoring company. There are 3 other non-factoring industry members. At the present moment, we have a lawyer, a human resources director, and a professor of finance. And then there are 3 members coming from the Factoring Association. It's interesting that in the 8 years that we've operated this, there've only been 4 changes to the guidance. So they are general, they are principled, and they've stood the test of time. It does not itself deal with the complaint. As I explained, these go elsewhere, but it can make recommendations about a member's conduct and practices, and it can recommend to the trade association that a member's be terminated, that his membership be taken away. That has never yet happened, but it's there as a final sanction. Next slide, please. Possible future direction. First of all, we've got possible future direction, regulation on the one side, and model law of factoring on the other. I won't deal in any detail with issues for a model law. That will take a day in itself. But regulation, let's have a look at regulation. Next slide, please. What are the let's be clear as to what we think the advantages are and what we're trying to achieve. Clear rules for everybody. So you should have fair competition. It should ensure that proven business standards, international standards are used. You keep out the cowboys. You keep out the mafia operators. And financial side, minimum capital, and solvency rules. In my view, where I've seen regulation, if it is sensible regulation and not overbearing, it helps the reputation of the factoring industry and it reassures investors in factoring companies and the clients. The disadvantages, I think we can cope with that. There will be an element of bureaucracy and red tape, and there will be time and cost of complying. And if people are penalized, well, then there will be reputational damage. So as I put as a final thought to this, what current bad aspects of factoring do you want the regulations to clean up? That's a question. Next slide, please. As for a model law, the advantages would be certainty. Factors can input at the development stage, and what you need is something that is easy for judges, clients, and debtors to understand without having to use expensive lawyers. But what it will give investors, clients, debtors, third parties, they should then know their position in one easy document. But, and it will need a well-functioning court system with knowledgeable judges for it to be effective. Next slide, please. Next slide. Well, far be it from me to tell you what you should be aiming for. So, possible contents with a question mark. I do this with hesitation. But the use of the word factor in your title, or describing yourselves as a factor, should be something that needs qualification. And therefore, if you're qualified as a factor, then you're registered and licensed. The next issue is a public registry. Should there be a public registry of factoring assignments or factoring agreements? Then you come to the question of financing, qualifications for staff. Then the one that always causes us problems is information that must be given to clients, and most importantly, fees, how they are calculated and what the maximum amount, and what should be the sanctions for non-compliance with the regulations. What I would urge you to do is to avoid defining the products. Let the market develop the products via contract law. You don't need the government to tell you what goes into your product, because the product will develop through competition. Next slide, please. And then what to include in the factoring law. Next slide, please. Well, you need certainty, and the certainty in having a law on factoring would be that it should be easier for investors to fund, and you should avoid unnecessary disputes with clients and debtors. But there are four things that a factoring law should explain, and these would be the rights and obligations of the parties involved. The obvious ones are the factor, the client, and the debtor, but there are other parties who may have an interest, other security holders, judgment creditors, parties involved in an insolvency. Next slide, please. I think this is self-evident, but I think in due course you should be aiming for a law only about factoring. Expect to include improvements, particularly internationally accepted commercial factoring. So it should be domestic factoring and cross-border factoring. Next slide, please. I've set out here a list of possible contents of a new factoring law, which occur in other countries' laws. The form of the assignment, the form of the notice of assignment, what happens when you give a notice of assignment, what are the rights that will be assigned to you with the receivable. Very important that the debtor rights are clearly understood, as are the rights of third parties. Next slide, please. I think this is detail that probably can go on to another occasion. I would, however, emphasize item 3, that any law must cover the possibility that in one assignment you can assign both present and future debts. And by future debts, I mean debts, receivables that have not yet been created, for which there may not even be a contract. The 5th item is quite important because we all concentrate upon the assignment of receivables, and it's very important to consider what else do you need to be assigned to you, such as evidence of the receivable. What rights do you have to enforce the receivable? Number 7 is one that I'm often asked about. What happens if the same receivable is fraudulently assigned twice to get twice the payment? And this is worth setting out. And there are a number of potential answers. Just consider which is most suitable for you. And the last one, number 8, rules for nullifying prohibitions on assignment. One of the biggest areas where factoring can be stopped in its tracks is the buyer, the debtor, putting a clause in its contract saying that the receivable cannot be assigned. Now, this, as a matter of contract law, is enforceable. As a matter of public policy, it's a very bad thing, and the movement is towards nullification of such provisions. It takes a lot of thought, and I spent nearly 2 years negotiating on behalf of the industry with the UK government, so that a year ago, 2 years ago, they passed a law setting out that in general, prohibitions on assignments could not be enforced. So think that one through. It's not as easy as it sounds, but if you get it, it will enhance the product and will encourage the financing of SMEs. Next slide, please. These are details which I think, in view of the time, there is no need to go into, and I think I mentioned it last time. So let's go to the next slide. Next slide, please. And next slide, just the effect of notice of assignment. I mentioned the double assignment, the fraudulent double assignment. It is important that the law gives guidance as to which factor has the priority. Do you choose between the first assignment in time or the first to give notice of assignment? And then what do you do if the first to give notice of assignment knew of the prior assignment? And then you come into the whole issue of public registration. Next slide, please. This I have already dealt with. Next slide, please. Yes, very important that you are clear in your own mind that when a receivable is assigned, what also comes with it. We call them related rights, associated rights, and they're generally rights which assist in payment. And I think they're self-evident. You need evidence of the debt, so documents, proof of delivery, documents of title, guarantees, excuse me, and credit insurance. Make sure you get the assignment of your client's credit insurance. Next slide, please. Next slide. Just, I emphasize that the product is the result of the factoring contract. And this is not something you should try and legislate for. But there should be automatic guarantees by the client, by the warranties, that it actually does own the debt and has the right to assign it, that has not previously been assigned. And for those of you who are offering credit protection, that there is no defense or set-off, and that there are no prohibitions. But you may say, well, that's very difficult. Well, then you and the client can agree that the whole or any part of a model law should not apply. Next slide, please. You may care to exclude certain debts from your model law, and they again are complex arrangements which I've listed there. Next slide, please. Very important to give reassurance to the debtor that once he gets a notice of assignment, that his position really is not adversely affected. And therefore, it would be useful in any model law to set out the debtor's position. Next slide, please. One of the main issues we have in any court proceedings against a debtor is what defences and what set-offs can be raised against a factor. And these, I think, are very, I mean, it's sensible, it's self-evident. So if you've got damaged goods, of course, he can refuse, but it's worthwhile spelling this out. And then there are the closely connected contracts. So I've suggested that if there is a maintenance contract for a photocopier, and the photocopier has also been sold, and they're two separate contracts, breach of the maintenance contract should be set off against the sale of the goods. And then there's the whole issue of contra trading, which is worth mentioning. But remember that the debtor can always agree in writing not to raise defences and set-offs against a factor. You must only raise them against the factor's client. Next slide, please. And there we are. Thank you very much. Obviously, I'm more than happy to help in any way if you need what is basically experience of a trade association and some of the problems you can have. But I hope you found it of interest, and I wish you every success in the development of factoring and using a trade association for the protection of your good reputation and for the benefit of you, your clients and your staff. Thank you very much. I'm more than happy to take questions if you'd like to write them in, and it will give me a chance to give you some detailed answer. Thank you so much.
Edward, thank you very much. Really, it was an excellent presentation again, and you touched new topics after the meeting you had with our colleagues in Ukraine on Monday. Thanks so much, especially for the importance of the development of a trade association in a new country and developing country. This is really very important. I have